When was the last time you took 2 full weeks off, didn't check your email, didn't call into the office, and let your practice run without you? For many attorneys, the honest answer is that they have never done it. Powers and McNalis report that it is not unusual for them to encounter attorneys who have not taken a real vacation in 10, 15, even 20 years. Today we're looking at why that's a problem. Not a quality of life problem, although it is that. A structural problem with the practice itself, because the vacation is not just a reward for building a good practice. The vacation is the test of whether or not you actually built one. You will not want to miss this. I'm Robert Bunn, and this is Estate Planning for Lawyers. Quick housekeeping before we dig in. Nothing in this podcast is legal advice, and no attorney-client relationship is created by listening or watching. There's a full disclaimer at the end. If you're listening on Spotify, Apple Podcasts, Amazon Music, iHeartRadio, or another audio platform, thank you. I'm glad you're here. If you have a moment, I would encourage you to subscribe on YouTube as well, because the video adds another layer of the conversation. And you can see my beautiful Hawaiian shirt. And if any of this is useful to you, please consider sending it to another attorney who might benefit. And thank you for watching on YouTube as well. The authors are Powers and McNalis, and the book is Time Management for Attorneys, A Lawyer's Guide to Decreasing Stress, Eliminating Interruptions, and Getting Home on Time, published by Atticus. They argue in Chapter 9 that taking and planning a vacation in Chapter 9 is the single most effective way to determine whether the practice you have built can function without you. Not just determining if you can take time away, but an incredible opportunity. In the prior episode, episode 10, we worked through Chapter 8 on delegation. We talked about self-enhancement bias, the leverage ratio, the 4 levels of trust, the risk and complexity matrix, the designated hitter, and the SMART rules. The central argument of that entire chapter was that the attorney who refuses to delegate have built themselves a more expensive version of the job they used to have. Chapter 9 is the proof of concept. Everything we have building across the prior 8 chapters come to a single test. Leave the office for 2 weeks. Do not call in, come back, and look around. If the practice is running smoothly, the clients are calm, and the desk is not buried under 2 weeks of unopened mail. The systems work. If you come back to chaos, the systems do not. The vacation in this framing is not just a luxury, it is also a diagnostic instrument. Powers and McNalis opened the chapter with an argument I want you to contemplate. The authors argue that planning and actually taking a real vacation is the single most effective way to find out whether the office you have built is genuinely systemized, whether your team has been trained well enough to operate without you in the room, and whether the practice itself can run when you are not present. Read another way, that sentence is saying something more direct. If you cannot take a vacation, you do not have a practice. You have a job. The structure you have built is one that requires your continuous personal attention to keep functioning. The moment you remove yourself, it collapses. That is a definition of a job, not a practice. A practice can survive its owner being absent. A job cannot. And I want to give you that distinction up front. It is the lens from which the rest of the chapter makes sense. The authors then walk through the reasons attorneys give for not taking a vacation. The list is funny in its familiarity. I want to share a few of them because I suspect you will recognize some of them. The first is that the calendar will not allow it. The court schedule will not cooperate. The closings are stacked. The state administration deadlines are too close. There's always something on the horizon that makes the next month worse than this one. The second is that the clients cannot manage without the attorneys present. Mrs. Smith calls it every week. Mr. Jones has questions only the attorney can answer. The family, the decedent is in the middle of a difficult administration and needs the attorney available. The third is that the partners have not taken vacations either. The cultural signal in the firm is that the people who advance are the people who stay. Taking a vacation feels like breaking ranks. The fourth is that the workload is just too heavy at the moment. The thinking goes, perhaps once things calm down, perhaps once the backlog is cleared, the time will come. It does not come. The fifth is that leaving is more work than staying. The 2 weeks away will cost 4 weeks of effort between the scramble before departure and the dig out on return. The math, in this view, does not favor going. The sixth is the bar conferences and continuing legal education events provide enough travel. The attorney leaves the office a few times a year for those. That is treated as a substitute for actual rest. Powers and McNalis are sympathetic to each of these reasons. They're also clear that none of them is actually a reason. They're symptoms. The reasons attorneys give for not taking vacations are the same reasons the attorney needs a vacation in the first place. A practice that cannot survive your absence is a practice you have not finished building. The vacation is what reveals that. The chapter then gives you a logistical framework for actually taking the vacation. The framework is structured by time. 1 year to 6 months out, 6 weeks to 1 month out, 2 weeks out, 1 week out, the final week. I'm going to walk you through it briefly, but I want to be clear up front that the full treatment is in the chapter. You should read it directly if you're planning a vacation anytime soon. The framework is short enough to read in 20 minutes. The headline moves are these. At 1 year to 6 months out, you put the vacation on the calendar. That is the single most important step. Vacations that are not on the calendar do not happen. The authors also recommend a move I want to flag because I think it is brilliant. They call them phantom days. A phantom day is a day on which you are physically back in the office, but the clients do not know it. You use those days to dig out before the client load resumes. Book in the vacation with 1 or 2 phantom days on the back end, and you eliminate the dread of returning. You also start lining up backup counsel a year out. For a practice without an internal backup, the author suggests a reciprocal arrangement with another attorney you trust. You cover for them when they leave. They cover for you when you leave. With 6 weeks to 1 month out, you meet with the team to anticipate which client situations might become problems. You brief the backup attorney. You start telling clients you will be away, and you introduce them to the backup if appropriate. For litigators, you begin coordinating with opposing counsel and the courts. Most opposing counsel will cooperate, the authors note, as long as you give them enough lead time. At 2 weeks out, you update the contingency list. You brief the designated hitter. If you do not have a designated hitter, you schedule the staff to make proactive check-in calls to clients during your absence. The authors include a sample script for those calls. At 1 week out, you set up mail triage. You make sure someone in the office is going to open both the physical mail and the business email during your absence. Identify anything urgent, distribute it to the right people, and categorize the rest. You set up an autoresponder if appropriate. In the final week, you have one last meeting with the backup attorney to confirm they have the latest information on every active matter. I want to take a moment on something important. The authors do not address it directly, but it follows from everything we have discussed in this series. Taking a vacation does not relieve you of your supervisory duty under the rules of professional conduct. Florida's Rule 4-5.1 and 4-5.3, and the equivalent rules in every other state, do not pause when you board the plane. You remain responsible for the work product of the people covering for you. You remain responsible for ensuring that the backup attorney is competent, that the staff is supervised, and that the client matters in progress are handled appropriately while you're away. The systems we have been building across the series, the checklists, the model files, the delegation forms, the levels of trust are what make it possible to satisfy those obligations from a distance. But the obligations themselves do not go away simply because you're away. I flag this not to discourage anyone from taking a vacation, the opposite. I flag it because taking a vacation responsibly is one of the highest expressions of the systems building work that this book has been teaching us. Please check your own state's rules of professional conduct and bar rules and then structure your vacation accordingly. I want to pause on a specific argument the authors make towards the end of the chapter, because I think it is the single most important thing in the chapter, and it is easy to miss. The authors claim that the second week is where the real benefit lives. The first week is decompression. Your body and mind are still in work mode for the first several days. The stress level takes time to drop. Real perspective does not arise until you are deeper into the trip. The authors believe that 2 weeks of separation from the technical work of the practice produces breakthroughs in how you think about and run that practice. The new ideas, the new perspectives, the structural rethinking, none of it happens in the office. All of it happens after the second week of separation. This argument is doing more work than it appears. It is not saying that vacation is nice. It is saying that vacation is a structural input to the practice. The thinking you do about the practice from inside the practice is constrained by the practice. The thinking you do about the practice from outside it, with enough distance to actually see it, is qualitatively different. And that different thinking is what produces the moves that grow the practice. I want to recommend a book that goes much deeper on this argument. For those of you who want to read further, the book is Rest: Why You Get More Done When You Work Less, by Soojung-Kim Pang. Pang's argument, supported by extensive research, is that deliberate rest is not the absence of work. Deliberate rest is the input that makes deep work possible. He draws on the daily routines of scientists, writers, and creative professionals across centuries. And he shows that the people who produced the most original work were often the people who built the most disciplined rest practices around their working hours. Pang's frame is consistent with what Powers and McNalis are arguing in this chapter, but he extends it from vacation specifically to the rhythm of working life in general. If you find yourself resistant to the argument that vacation is structural rather than indulgent, Pang's book is, in my view, a thorough rebuttal of that resistance. Here's the part of the conversation where I turn theory into something you can act on. 5 things you can do this week. 1, put a vacation on your calendar. Not a long weekend, a real vacation. 2 weeks, ideally. Pick a window 6 to 12 months from now and block it. The vacation that is not on the calendar does not happen. The vacation that is on the calendar starts changing how you think the moment you put it there. 2, identify your backup. If you have an associate or partner who can cover, name them. If you do not, identify one attorney or network with whom you can set up a reciprocal arrangement. You cover their practice when they leave. They cover yours when you leave. The conversation does not have to happen this week. Just identify the person. 3, block phantom days on the back end of your next planned absence, even a short one. 2 days where you are back in the office, but the clients do not know it. Use those days to dig out before the client load resumes. The next time you take any time off, even a long weekend, try this once. You will not return any other way after that. 4, make a list of your most volatile client matters, the matters where something could go wrong in the next 2 weeks. Write down what the contingency would be in each case. The list is useful even if you're not leaving. It also tells you which matters need extra structure before you can leave. 5, pick a date by which you will be ready to take a real vacation. Not the date of the vacation, the date by which the systems will be in place to make the vacation possible. 6 months from now, 12 months from now, whatever the honest answer is. Write the date down. Work backwards from it. Do those 5 things and the vacation stops being an abstract aspiration. It becomes a project with a deadline. My personal takeaway from this material is this: the attorney who cannot leave the office for 2 weeks has built something fragile. The fragility is not a personal failing. It is a structural fact about the practice. And the way to address it is not to work harder, or to be more available, or to develop better coping mechanisms for the stress. The way to address it is to build the systems that make the practice resilient enough to operate in the attorney's absence. That is what the previous chapters have been about. Chapter 9 is a test. The vacation is the moment you discover whether the systems work. My personal advice, same 3 lines I've been leaving you with across the recent episodes. Protect your time, guard your focus, expand your leverage, to which I will now add a 4th. drawn from this chapter. Prove the practice works without you. The first 3 lines are about how you spend your working hours. The 4th is about what the practice looks like when you're not working at all. A practice that passes the 4th test has earned the first 3. Before I go to the close, I want to say something I've been waiting 11 episodes to say. This is the final episode as we walk through Time Management for Attorneys by Powers and McNalis. 11 episodes ago, I sat down to read this book carefully, chapter by chapter, and to share what I found with you. The journey has changed how I think about my own practice. My hope is that some piece of it has changed something for you too. If you've been with me from the beginning, or even from somewhere in the middle, and you've stayed through to this episode, I would consider it a real kindness if you left a comment below. Tell me you made it through. Tell me which episode or which chapter landed hardest. Tell me what you are taking with you from the series. I will read every comment personally, and I will respond to you by name. The fact that you stayed for the full conversation matters to me. Thank you. This series had been built around one book. The channel itself is built around something larger. My intention is to continue working through the books, the practice guides, and the professional authorities that I find genuinely useful for attorneys building a serious practice. Some will be classics, like the one we just finished. Some will be newer. Some will be books that nobody is talking about anymore, but that I think still have something to say. The format will be the same. A careful read, a faithful summary in my own voice, and an honest accounting of how the material lands for an attorney actually trying to apply it. If that's the kind of conversation you want to keep having, please stay with me. The next series is already in the works, and I look forward to your continued support. Before we close, thank you again for spending your time with me today. I know your time is valuable. The fact that you spent some of it here on this conversation matters to me. My hope is that, again, the information was useful to you, something you can put to work the very next time you sit down to do your most important work. To reiterate what was said at the beginning, nothing in this show is legal advice, and no attorney-client relationship is formed by listening or watching. The information presented here is general and educational, and it is not a substitute for advice from a licensed attorney in your jurisdiction reviewing your idiosyncratic facts. The views I share are my own on behalf of Bunn Law PLLC. All references to Time Management for Attorneys, A Lawyer's Guide to Decreasing Stress, Eliminating Interruptions, and Getting Home on Time by Mark Powers and Sean McNalis, published by Atticus, are made for commentary and educational purposes only. All rights in that work belong to their respective owners. My discussion is commentary and analysis, and neither the authors nor the publisher have endorsed or affiliated with this show. Again, I recommend everybody buy a copy. Subscribe to Estate Planning for Lawyers so you will not miss our next show. I will see you there.